Hello everyone and welcome back to my YouTube channel. In today's lecture, I'm going to explain you the subject of jurisprudence and its exam structure. Our today's discussion is going to be on part A of the exam, which is a compulsory question which every candidate has to attempt in the paper. And this video is specifically designed for the year 2024 exam, which is same for both May and June and October. So if you're preparing for the exam of May-June 2024, this video will definitely help you to prepare the answer for part A. Now, having said that, jurisprudence exam of University of London program contains two parts. The first part is the part A, which is a set case which is released by the examiner every year. So इससे पहले हमारे पास मुख्तलिफ cases रहे हैं. We had cases such as Lee versus Asher Bakers, R versus Brown, R versus R. We had cases of Google LLC. We had the case of Conway versus Secretary of State. So हर साल का केस जो होता है वो रिलीज़ करता है एग्ज़ामिनर, जो कि आपके VLE के ऊपर अपडेट में आ जाता है. इस साल का भी केस बड़ा इंटरेस्टिंग है और वो रिलीज़ हो चुका था समवेयर इन नवंबर. अब उसके ऊपर आपने पार्ट ए में कोई एक चॉइस में से क्वेश्चन करना है. पार्ट बी में इट कंटेन्स 9 essay questions on different topics covered under the UL study guide that covers areas such as positivism, natural law theories, मार्क्सिज्म, फेमिनिज्म एक्सेट्रा. सो वो सारे जितने टॉपिक्स हैं वो उस पार्ट बी के अंदर कवर होते हैं. तो पार्ट ए को तो आपने हमेशा, बेशक वो क्लोज बुक एग्ज़ाम हो या ओपन बुक एग्ज़ाम हो, आपने उसको प्रिपेयर करना होता है ऑन अ पर्टिकुलर एरिया जो कि एडवाइज्ड होता है. सो व्हेन वी टॉक अबाउट द केस फॉर दिस ईयर that is going to be examined in part A is the case of Dulgheriu versus Ealing of London Borough Council. This is a 2019 decision. ये पार्ट बड़ा important है because this is called the citation of the judgment and you have to make sure that you follow the citation of the judgment accurately because otherwise there is already a decision pending जो कि हाई कोर्ट का है, वो आ चुका हुआ है. उसकी एक डिफरेंट साइटेशन होगी. वी आर नॉट कंसर्न्ड विद दैट डिसीजन, वी आर प्राइमरीली कंसर्न्ड विद द डिसीजन ऑफ द कोर्ट ऑफ अपील. अब this is a court of appeal judgment. Be mindful about the citation since we are required to go through the judgment of the court of appeal, not the high court. And the matter was actually sent to the Supreme Court, but the leave to appeal was not granted in the year 2020. So Supreme Court का तो इसके ऊपर कोई फैसला ही नहीं है. So our main case is Dulgheriu versus Ealing of London Borough Council. Now the judgment you can download from your VLE as well from the online libraries. जो आपका actual तरीका है Westlaw या LexisNexis को use करके you can download by using the particular citation. But an easy way out would be that just write down the complete citation along with the case name on Google. I think it's the first or the second review from the Court of Appeals website that you can download this decision. The first page would look like something which is displayed on the screen. It talks about you just have to make sure that the citation is the same one. And the name of the judges, the name of the parties, everything is on the first page. Just download this judgment and the first task is to actually read the judgment. Now, your task is to read the judgment thoroughly. Of course, you have to do it. There's no way around it because, well, your entire argument will stand on the judgment along with the theory. So unless and until you know the very reasoning, the very prudence of the judgment, you would not be able to talk about it. The focus on the reading should be on the philosophical issue and reasoning of the court court have adopted to the controversial issue raised before the court. So एक mistake part A के अंदर students करते हैं कि just like LSM part A, they tend to make a case note. You're not supposed to make a case note for jurisprudence part A. You're supposed to extract the philosophical debate that took place in that judgment. So आपने जो controversial concept, obviously जो judgment होगी उसमें कोई ना कोई डिबेटेबल मैटर होगा. ऑफ कोर्स उसी जजमेंट के अंदर लॉ भी बहुत सा होगा. तो जो लॉ है या जो रेलेवेंट प्रोविजंस हैं, जो सेक्शंस हैं, वो हमारे लिए बहुत ज़्यादा इंपॉर्टेंट नहीं हैं फॉर द डूइंग ऑफ द पार्ट ए, बिकॉज हमारा जो कॉन्सेप्ट है वो फोकस करेगा फिलोसफिकल डिबेट पे रादर दैन लीगल या फैक्चुअल कंट्रोवर्सीज पे. Focus should not be on contentions of the law. Rather, we are much concerned about the legal procedures. तो हमारा ना तो लीगल प्रोसीजर से कोई ख़ास तल्लक है, ना कि कंटेंशन ऑफ लॉ से है. आर डिबेट वुड बी ऑन द जूरिस्प्रूडेंशियल डिबेट रादर दैन legal. Now, the option to prepare. This year, the examiner has provided us with 3 options. हमारे पास इन तीनों में से कोई एक option है choose करने के लिए. We can either adopt to write our answer from the perspective on the said case from either the feminist legal theories, liberalism and law, or Dworkin's theory. Now, the examiner suggests that when you are picking up any one of these areas, you need to go and read that very area from the guidebook, where they would actually not explain that area in a lot of detail, but at least would provide you with effective reading lists that you need to consult in order to form your opinion about the judgment. So we're picking up liberalism and law, and I have good reasons as to why. So why liberalism? Why am I picking up liberalism for the year 2024? And the answer is given on this slide. Your preparation should be based on chapter 10 of the module guide. Some of the questions you should be concentrating include: how does the set case relate to the justice theories? Does it tell us anything about the relationship between law and morality? How do the notion of autonomy, rights relate to the party's argument, and how are they addressed? What does the set case tell us about the individual freedom, expression, assembly, privacy in the contemporary society? Now, these are the questions. I think this is the last one. This one. Now, the extract that you see on the slide is the one that is coming out of the University of London, set case page, the information that they have released. ये उस पे उन्होंने सवाल रखा हुआ है कि जब आप ये केस तैयार कर रहे होगे तो आपने ये सवाल अपने जहन में रखना है. तो आई थिंक दिस इज़ प्रीटी मच द क्वेश्चन that is going to be posed before us in the exam in 2024. That is, how does the said case tell us about individual expression, freedoms, expression, assembly, and privacy in the contemporary society? Because our case primarily deals with all of these issues which are mentioned in this last question. Now, why liberalism? As I said, that I have to justify myself that why I'm not picking up feminism or the area of Dworkin, Ronald Dworkin, which is a very interesting theory as well. The answer is given on this slide. The case involves an issue of protest that was carried outside a reproductive health care clinic. So basically एक abortion clinic था, जिसको हम सेंटर भी कह रहे हैं, हेल्थ केयर क्लिनिक था, जिसके बाहर एक क्रिश्चियन ग्रुप जो था वो प्रोटेस्ट कर रहा था. मल्टीपल उसमें ग्रुप्स में लोग इन्वॉल्व थे, और वो जो प्रोटेस्ट करते थे उनका ये मौक़िफ़ था कि जो अबॉर्शन है ये एक उनके दीन के हिसाब से, उनके रिलीजन के हिसाब से एक कंट्रोवर्शियल और एक गलत चीज़ है, और उसकी बुनियाद पर वो लोग परसुए करने की कोशिश करते थे बाय प्रोटेस्टिंग उन लोगों को जो कि उस अबॉर्शन क्लिनिक को इस्तेमाल करते थे. सो दिस इज़ नॉट अ केस अबाउट अबॉर्शन. It's indirectly the court is talking about the controversial and sensitive issue of abortion, but this case is not going to regulate the behavior of abortion or no abortion, because that is something already decided by the law, और वो एक चीज़ lawfully और legally exist कर रही है UK में, और ये clinic भी lawfully काम कर रहा था. In my opinion, why choosing liberalism is more important is because this is a case about freedom of expression, freedom to express or have religious views, and most importantly, the right of privacy. So for me, these are the issues that are dealt primarily under the liberalism doctrine, because in liberalism, the theory has to justify the balance between the rights of others and the rights of one being, because we need to learn how much extent does a person enjoy the freedom where his actions might lead to physically harm other people or otherwise. So what are the limits of liberty? Are we talking about absolute liberty, or are we talking about qualified liberty? So what's all of that debate, I think, is more concerned with liberalism. Yes, feminism does have a lot of role to play, especially in light of autonomy of a woman. And because these abortion clinics were used by majority of women, that was not, of course, that has to be protected by the law. And so feminist legal theory is relevant and in that context. Similarly, if we talk about abortion, then radical feminists have a very specific point about the women's body and its own choices. And I think there is a very strong overlap of feminism on part A of this year. Now, why am I not preparing for feminism? I think the reason I think is purely based on planning of my, if I have to go for a paper, I would leave feminism for part B because that's a confirmed question as well in part B, and I want to prepare that area for part B, not for part A. So I would rather choose part A in liberalism and then do Marxism, feminism, Austin and Hart, or maybe Kelsen in part B. So coming to the slide, the Court of Appeal upheld the lower court's ruling that the imposition of the safety zone around the reproductive healthcare clinic was compatible with Article 8, which is right of respect of private and family life, Article 9, freedom of thought and conscience and religion, Article 10, freedom of expression, and Article 11, the right of assembly and association of the European Convention of Human Rights. The Good Counsel Network, a Christian anti-abortion organization, brought the challenge against the London Borough of Ealing in relation to the Public Spaces Protection Order, which prohibited pro-life protesters from engaging in their activities within the immediate vicinity of the clinic. The court recognized that the women's reproductive choices are intensely personal and sensitive matter, and that Article 8 protected the rights to access, advice, and medical procedure for abortion available under the UK law. The court found that there was sufficient evidence that the activities of pro-life group had detrimental impact on those of the community and that of their tactics caused lasting psychological and emotional harm to the service users. Therefore, after carefully balancing the fundamental rights, the court concluded the restriction of the protesters' freedom of expression, assembly, and conscience was justified and proportionate. So we just saw how the issue of balancing of rights need to be considered by the court, and this is where I feel that liberalism comes most handy. Now we first going to review the factual overview of the case. अच्छा, अब थोड़ा सा आप इस लेक्चर की सीक्वेंसेस को समझिएगा. आज के लेक्चर के अंदर एक छोटी वीडियो है. आज मैंने सिर्फ आपको पार्ट ए इंट्रोड्यूस करना था. आई एम गोइंग टू मेक अ स्पेसिफिक वीडियो अबाउट द philosophical debate which is relevant to the case. But that video will only come after we have discussed the concept of liberalism. So basically हम क्या कर रहे हैं कि हम अपनी तैयारी इस तरह से कर रहे हैं कि हम पहले इस केस का ओवरव्यू देख रहे हैं कि केस किसके बारे में और इस केस में क्या इशू आया और इसके मटेरियल फैक्ट्स क्या हैं, इसका जो पहले का फैसला था वो क्या था, वो सारी बातें आज करने के बाद हम जो अगला लेक्चर कवर करेंगे उसके अंदर हम लिबरलिज्म को पढ़ेंगे. लिबरलिज्म के अंदर मल्टीपल ऑथर्स आते हैं, तो उसमें हम स्टार्ट करेंगे जॉन स्टुअर्ट मिल से, फिर हम लॉर्ड पैट्रिक डेवलिन का जो कॉन्सेप्ट है इन्फोर्समेंट ऑफ मॉरल्स में मोरालिटी से रिलेटेड वो कवर करेंगे. उसके बाद हार्ट ने, प्रोफेसर एच.एल.ए. हार्ट ने एक किताब लिखी थी कॉल्ड लॉ, लिबर्टी एंड मोरालिटी. वो उस जवाब में लिखी गई किताब थी जो कि लॉर्ड पैट्रिक डेवलिन ने इन्फोर्समेंट ऑफ मॉरल्स के अंदर रेज़ किए थे. सो उसमें जॉन स्टुअर्ट मिल का जिक्र हार्ट ने ख़ुद किया हुआ है और उसकी थ्योरी को थोड़ा सा रिफ़ाइन किया हुआ है. तो हमारे 3 ऑथर्स तो ये हो गए. उसके अलावा फिर ग्लोवर का जिक्र होगा बिकॉज ऑटोनमी और जो राइट्स ऑफ विमेन के ऊपर ख़ास तौर पे अबॉर्शन से रिलेटेड जो चॉइस ऑफ लाइफ का जो कॉन्सेप्ट है ग्लोवर ने अपनी किताब में दिया हुआ, उसको आई विल बी डिस्कसिंग एज वेल. और लास्टली हम 2 ऑथर्स और को भी इंक्लूड कर सकते हैं यहाँ पे. रोनाल्ड डॉर्किन जो कि जिसने मोरालिटी के ऊपर और इन्फोर्समेंट ऑफ फंडामेंटल राइट्स के ऊपर अपनी थ्योरी में बहुत ज़्यादा फोकस किया था, वो भी लिबरलिज्म के डॉक्ट्रिन के अंदर कवर होता है. और फिर लास्टली है राज, जोसेफ राज, जिसने मोरालिटी ऑफ फ्रीडम जिसकी किताब के अंदर यही कॉन्सेप्ट जो है मिल का जो प्रिंसिपल था उसको, हार्म प्रिंसिपल को उसने ऑटोनमी के साथ लिंक किया हुआ है. देयर आर मोर ऑथर्स ऑफ कोर्स, आप इसके अलावा भी ऑथर्स की तरफ जा सकते हो. दिस इज़ अ वेरी रिसर्च ओरिएंटेड एरिया. आप इसमें जितनी ज़्यादा रिसर्च करोगे उतना ज़्यादा आपको मार्क आने का चांस है. नाउ एक बात जहन में रखनी है, यू शुड बैलेंस आउट योर आर्ग्यूमेंट बिटवीन द जजमेंट एंड द थियरी. A lot of common mistake that I've seen in students that they either focus too much on the judgment or they focus too much on the theory. So I would suggest you कि आप दोनों का बैलेंस आउट करें और वो आपको फिर एंड पे इवेंचुअली जब मैं बेसिकली मैंने कर रहा आपको स्टेप्स में वही बता रहा था. तो स्टेप 1 कि आज आपने ये ओवरव्यू सुन लिया, उसके बाद स्टेप 2 इज़ टू स्टडी लिबरलिज्म. आप लिबरलिज्म डॉक्ट्राइन की जो थ्योरीज़ हैं उनको ब्रीफली कंसिडर कर लेते हो, उनके पॉइंट्स, उनकी कोटेशंस आप एक जगह पर लिख लेते हो, and then you read the judgment फ्रॉम द फिलोसफिकल facets ऑफ द जजमेंट, और उसके अंदर वो जो पॉइंट्स हैं उनको आप कोशिश करते हो कवर करने की। तो हम वीडियो में भी एक ऐसी डिस्कशन की वीडियो बनाएंगे जिसके अंदर जो पैराग्राफ्स मुझे लगता है रिलेटेड हैं लिबरलिज्म से, डॉर्किन से या राज से, उनकी डिस्कशन मैं आपके साथ एक अलहदा वीडियो के अंदर करूँगा। सो देयर विल बी 3 डिस्टिंक्ट वीडियोज़ एंड द फोर्थ वन वुड बी ऑन हाउ टू स्ट्रक्चर योर आंसर, जिसके अंदर मैं सिर्फ एक जो सेट क्वेश्चन है उसको आंसर करना सिखाऊंगा कि आपने किस तरह से एक ऐसे क्वेश्चन को पार्ट ए में आंसर करना है। सो लेट्स dive into the facts of this case. The appellants are associated with a Christian group called the Good Counsel Network. So इसमें जो basically जिन लोगों ने केस फाइल किया है वो एक क्रिश्चियन ग्रुप है जिसका नाम गुड काउंसिल नेटवर्क है। द GCN एंड अदर प्रो लाइफ कैंपेनर्स congratulated on a daily basis, on weekly basis outside the clinic or the center which provides family planning services including abortion services. So जो initial facts हैं वो ये हैं कि basically एक Christian group था जो कि regular basis के ऊपर एक clinic के बाहर इकट्ठा होता था जिसको हम center कह रहे हैं। There they attempted to dissuade the users of the center from having abortion by displaying lifelike fetus dolls, threatening that users of the center, pursuing user centers with leaflets, not leaving users enough room to pass into the centers, taking photographs, and using the clinic. Uh, there were attempts to settle the tensions between the two groups, however, the efforts failed. It was then the Borak of Ealing prepared a draft of PSPO and engaged in a statutory consultation. The consultation included the production of a report based on surveys and submissions by citizens of the community. According to the report, there were evidence of detrimental impact on the quality of life of the people in the community, and 83.2% of the respondents of the consultation agreed overall with the scope of proposed safe zone outside the center. यहाँ पर एक बात mention करना बड़ी important है कि under the PSPO order, there was no ban on the protest per se. There was no absolute ban. So the thing was that they created a safe zone. और इस safe zone के अंदर 100 meters की vicinity के अंदर protesters were not allowed with the center. So center से थोड़ा दूर करके इन लोगों को एक ख़ास तरीके से तरतीब से प्रोटेस्ट करने का कहा गया। Therefore, it was recommended that the PSPO was made. So ये जहन में रखिए कि जो लोकल अथॉरिटी थी जिसने ये PSPO ऑर्डर एंटी सोशल बिहेवियर एक्ट के अंदर में किया है वो एक इन डेप्थ कंसल्टेशन और वहाँ की रिपोर्ट्स को देख के जो लोगों ने अपना फीडबैक दिया, तमाम कम्युनिटी के लोगों के, ना जस्ट क्लिनिक यूज़र्स ने बल्कि वो लोग जो वहाँ रह रहे थे उन सब का जो फीडबैक था उसको कंसिडर करने के बाद ये PSPO ऑर्डर मेक किया गया है। So the Anti-Social Behavior Crime and Policing Act 2004, Ealing had the power to make such orders under the Anti-Social Behavior Crime and Policing Act 2014 if it was satisfied that the following conditions were met. The activities carried out in public place within the authority's area have had or were likely to have detrimental effects on the quality of the life of those in the locality, and the effect or the likely effect of the activities were not continuing nature, which would make the activities unreasonable and justify the restrictions imposed by the notice as per section 59. Therefore, the PESPO prohibited anti-abortion protest in the immediate vicinity of the center, which was within the safe zone. Now, the protesters, the protester group GCN, they went to the High Court, challenging the London Borough's Ealing use of Section 59 to pass the PESPO order. So the appellant, the GCN, proceeded before the Queen's Bench of the High Court in effort to quash the PESPO and on the following grounds. Firstly, before the High Court, they claimed that there was insufficient evidence was presented to them to be satisfied that the activities of pro-life group had detrimental impact on those in the locality. The prohibition by the PESPO were more extensive than was reasonable to prevent the detriment alleged. And thirdly, the prohibition in the PESPO violated Article 9, freedom of thought and religion, and freedom of expression, Article 10, and freedom of assembly under Article 11, and Article 14 was also engaged as prohibition of discrimination under the ECHR. The judge rejected the argument that the meaning of those in the locality was limited to those who reside or work or regularly visit the clinic or the locality, and could therefore not include occasional visitors to the centers, as it would deprive the Bora the power to the PSPO in relation to the detriment suffered by mainly the transit population. So the High Court basically ruled against the petitioners being the Christian group of the protesters, and therefore the clinic also had made representations there, and of course the Ealing had made detailed submissions before the High Court, and the court favored in towards the respondents who were in this particular case. So the decision of the High Court, the judge rejected the argument that meaning of those locality was limited to those who work regularly. ये मैं पहले ही पॉइंट एड्रेस कर चुका हूँ कि उसने एक्सटेंड कर दिया, उसने कहा सिर्फ जो क्लिनिक यूज़र्स हैं उनकी हद तक ये ऑर्डर लिमिटेड नहीं है, बल्कि जो लोग वहाँ पर रह रहे हैं उनकी ज़िंदगी में एक बहुत डेट्रीमेंटल इफेक्ट आ रहा था इस पर्टिकुलर एक्टिविटी से. Therefore, the judge reviewed the evidence on the detrimental impact of those in the locality and concluded that the Bora had justified the grounds to issue the order. The judge observed that the second and the third grounds were interconnected. He further referred to Article 8, which provides for the right of respect for private and family life, and held that the activities of pro-life activists invaded the right of privacy under Article 8. So basically, court ने weigh down किया है between Article 8 versus Article 9, 10 and 11. The judge observed that the restrictions on the protesters' right under Article 10, 9, 11 and 14 were prescribed under Section 59 of the Anti-Social Behavior Act 2014. Further, he held that the protection of the user's privacy was a legitimate aim with which PSPO had rational connection. So that said कि जो एक ऑर्डर पास किया गया है PSPO के अंदर वो उसका एक कॉजल लिंक है between the restriction placed for the freedom of expression, thought, assembly and religion with the right of privacy and family life. Now, there was an appeal that was filed by originally the petitioners, the Christian group, because they lost the case from the High Court. और High Court ने कहा कि जो PSPO को ऑर्डर पास किया गया है वो दुरुस्त है और वो legitimate एम परस्यू कर रहा है जो आर्टिकल 8 की प्रोटेक्शन का जिक्र अदालत ने किया. उसके ऊपर जो इस ग्रुप ने अपील की और ये अपील कोर्ट ऑफ अपील के सिविल डिवीज़न में हुई. और इसके अंदर जो ग्रुप था उनके लॉयर्स ने ये पॉइंट्स रेज किए. दीज वर द ग्राउंड्स ऑफ अपील which had to be considered by the Court of Appeal. The judge added in holding the phrase those in locality under Section 59 of the Act applies to occasional visitors such as women who visit for the abortion clinic for abortion procedures. The judge added in failing to adopt merit-based approach to justification of the PESPO. The judge added in holding Article 8 ECHR rights of those using the centers were engaged. The judge added in giving too little weight to the appellant's Article 9 of ECHR. In other words, basically, ये अपील के ग्राउंड ये कह रहे हैं कि जो फर्स्ट इंस्टेंस पे जज साहब थे हाई कोर्ट का जो मिस्टर टर्नर, उन्होंने जो फैसला किया है वो गलत इसलिए है क्योंकि उन्होंने हमारे राइट्स का ख्याल नहीं रखा और ज़्यादा राइट्स का ख्याल रखा है उन क्लिनिक यूज़र्स के. द जज फेल्ड टू गिव any sufficient consideration or whether the terms of the PESPO could have had formulated a less restrictive way. So उनका ये भी कहना था कि ये proportionate नहीं थी जितना उन्होंने बैन किया है. There were less restrictive way of protecting the rights under the said articles. When considering whether the PESPO constituted an interference that was necessary in the democratic society, the judge gave insufficient weight to the appellant's right of Article 10 and 11, which is the right to assembly and freedom of expression and religion. So ये कुछ ग्राउंड्स थे जिनके ऊपर कोर्ट ऑफ अपील के अंदर ये लोग आए. अब डिसीजन ऑफ द कोर्ट ऑफ अपील, एक्चुअली कोर्ट ऑफ अपील ने भी 3 जजेस ने बैठ के जो इस क्रिश्चियन ग्रुप की अपील थी उसको भी रिजेक्ट कर दिया और मिस्टर टर्नर जो हाई कोर्ट के जज थे उनका फैसला अब होल्ड किया. द कोर्ट रिजेक्टेड द आर्ग्यूमेंट स्टेटिंग दैट द प्रोटेस्ट डिड नॉट मेरली कॉज इरिटेशन अनॉयंस विच फॉल विद इन द प्रोटेक्शन ऑफ आर्टिकल 10 and 11 but extended to have detrimental effect on the quality of life of those who were using the or visiting the center. Now this is very important, detrimental effect, because this is the part which is compelling me to write part A from liberalism perspective rather than any other perspective. The court found the tactics employed by the protesters caused lasting psychological and emotional harm to the service users. Hence, the PESPO was necessary to strike a fair balance between on one hand, protecting those important interests of the service users and on the other hand the rights of the protesters. So this statement that is coming out of the judgment of the Court of Appeal clearly lays down the balancing act which the court had to employ between the rights of Article 8 versus Article 9, 10, and 11 of the protesters. Accordingly, the court held that the PESPO did not have disproportionate interference with the protesters' rights. Further, the court rejected the claim for PESPO was any less restrictive means, which means that the court found that the PESPO order was a proportionate one and it did strike a fair balance when it made a safe zone of 100 meters away from the clinic. So this was the decision. Now, this decision does not talk about the रीजनिंग ऑफ द कोर्ट. द रीजनिंग वाली जो पार्ट है वो मैंने आपको पहले ही बताया है कि उसके ऊपर मैं अलहदा से एक डिस्कशन बनाऊंगा. आज का ये जो छोटा सा लेक्चर था इसमें सिर्फ जो डिस्कशन थी वो इस हवाले से थी कि पार्ट ए है क्या और हमने उसको किस तरह से प्रिपेयर करना है. कुछ फैक्ट्स और जो इस केस की सीक्वेंस है वो आपके सामने मैंने रखी है. अब इस वीडियो के बाद हमारी जो नेक्स्ट वीडियो है दैट इज़ गोइंग टू बी ऑन लिबरलिज्म. तो हम जॉन स्टुअर्ट मिल, डेवलिन और हार्ट को अब पढ़ेंगे और उसके बाद फिर हम 2-3 और ऑथर्स की भी अलग वीडियो बनाएंगे. उनको पढ़ने के बाद देन वी विल कम बैक टू द जूरिस्प्रूडेंशियल पार्ट, बिकॉज जब हम वो पढ़ लेंगे तब हमें समझ आएगी कि कोर्ट ने किस पार्ट पे आया लिबरल थ्योरी अप्लाई की भी है या नहीं की, या कोर्ट क्या मोरालिटी की डिस्कशन कर रही है या मॉरल्स की इन्फोर्समेंट की बात कर रही है या नहीं कर रही. दैट हैज़ टू बी ओनली कवर्ड आफ्टर once we are done with the theory part. So I hope you have understood the basic concepts. If you have still questions about part A or the video that I just made, feel free to leave the comments below. And once again, thank you very much for watching this video.